All right, are you going to be arguing this?
Yes, Judge. Yes.
I don't.
I'll let you view that and just let me know when you're ready. All right, we're going to go on the record. And 2024 CR 2338B and 2024 CR 2339B, State versus Mariano Rendon. Can I have parties announced for the record for the state?
Megan Galloway for the state of Texas.
Larry Bloomquist for the defense.
All right, we're here. The court received a request for a travel permit from pretrial services. The defendant is requesting to go to Vegas from December 30th, 2024 and returning on January 2nd, 2025. State, do you have objections?
Judge, so just we would request specific conditions with that. So a UA before departure and upon arrival, as well as prohibited possession of firearms.
All right, when you say UA upon arrival, you mean return?
Yes, yes, arrival and San Antonio, so return to San Antonio.
All right, do you have any objections to that?
No, Your Honor, and I will just let the court know he did travel one time before for business. We did a UA when he came back and he was clean. I have no doubt that he will remain so.
All right. All right, then the court will grant the request. There's to be a UA completed before you leave and a UA upon return. Do you understand?
Yes, Your Honor.
All right, is there anything else?
No, Your Honor.
All right, thank you.
Thank you, Judge.
You're welcome. Enrique Soriano, no?
Present with counsel.
All right, so have you received the blood discovery?
I got the, this is what we've received today, video dash cam. And then in terms of the laboratory diskettes, we don't have that yet. I went by the window this morning. It's not there, but they are
All right,
providing.
so where's the blood discovery?
Record that is,
Is this the dash man?
no, this is the blood discovery.
Okay, so the dash cam is the one that we were working for. I thought that's what this was.
No, the last time you all were here in August, my understanding that both parties agreed that there were no dash cams available. That's what the court has in its notes.
Is that
There's-
correct?
As far as I'm aware, yes.
So state, were you able to tender an offer? All right, Norma, on this case, set it for a plea deadline date in 30 days, please. All right, January 14th is going to be your plea deadline date. You need to let the court know whether or not you've reached an agreement. If you have not reached an agreement, your case will be set for jury trial.
All right.
So if you get the reset form from the coordinator, and once he signs the reset form, he's excused.
Yes, ma'am.
All right, thank you for dressing appropriately for court. You always do, though.
My pleasure, Your Honor.
Thank you. All right, if you'll just have a seat and they'll bring the reset form to you.
Thank you.
Kelly Cotner.
Just have some.
On this case, blood discovery in?
No. You have it?
I think that's incorrect. I think it's already provided.
All right, so yes, I have in my notes that blood discovery was received on November 18th. And the state was to tender an offer today.
Wait a minute. The diskettes have been given to me?
If I'm informed correctly, yes.
I don't have it in my file.
All right, he doesn't have it in his file. If you have a copy, if you could give him another copy.
And
And
I've been
then-
looking for the diskettes at the window. I mean,
All right, they have it, so you'll have it, but I have it as being tendered on November 18th.
okay, now there's an additional issue
Yes.
regarding,
If I recall correctly, I believe ADA Crespo was working on getting those from Universal City.
All right, can you call him and see what the update is on that?
I can call her. I don't know if she's gonna pick up.
All righty. We shall see.
Judge, the motion that we filed was more encompassing than that. We want to know not only the status of his cases, but if there's any cooperation agreements that he's having with,
Well, I can't answer your question until they tender what they have to you, or if they think it shouldn't be tendered until I do an in-camera inspection. So I don't have it.
well, okay, then just, I didn't want to limit it just to,
Mhm.
okay, very good.
All right. So this is what I'm going to do. I'm resetting this for January 14th. The disciplinary records need to be here in my possession, or either the person who has access to that needs to be here explaining why they don't have it. All right, Norma, if you recall this for January 14th, please.
And then I guess the diskettes for blood, I'll have to check on that because we don't have it.
Your Honor, I think those might be these,
What, the blood discovery?
this little folder that says Kelly Cotner Blood Discovery.
Okay. All right, there you go.
Okay, then I'll pick it up from them now.
All right, thank you. All right, thank you for dressing appropriately for court. Once you sign the reset form, you'll be excused.
Yes, ma'am. Thank you.
All right, you're welcome. John Roberson. Who's the attorney on John Roberson?
It's me, Judge.
All right, my understanding that you was going to file a motion with regards to jurisdiction.
I did.
Okay.
You don't have it?
No, I haven't. I just was stating what we're here for.
Yes.
All right, State, did you receive the defendant's motion to set aside the indictment based upon jurisdiction?
I did, Your Honor.
And have you had a chance to review it?
I have, Your
Are you in agreement?
Honor. No, Your Honor.
All right. Court is calling. Are you ready to proceed on your
Ready?
Court is calling 2024 CR 006-935, State versus John Roberson. Could I have parties announced for the record for the state
Andrew Harris Edelman.
defense?
George Sharman on behalf of the defendant.
And are you Mr. Roberson?
Yes, ma'am.
All right. The defense has filed a motion to set aside the indictment. State, are you prepared to proceed?
Yes, Your Honor.
All right. Defense, it's your motion.
Judge, basically, the line is that one of the enhancements that the state is using is a misdemeanor from Travis County. And the defendant, after he served his probation on it, was granted a pardon in 2004 as to that. And as a consequence, it's not a case, a judgment for purposes of enhancement of punishment because of the pardon. And the case that states that is Cuellar versus State.
Well, have you submitted any evidence to show? that he was pardoned?
There are attached exhibits to the motion. And these were the exhibits that were given to me by the state. And if you look at Exhibit 2, the language in Exhibit 2 says that the case was dismissed. And under 4212 Section 20, back in that period of time, the judge allowed him to withdraw his plea of
But
guilty.
let me ask you this, because I'm reading the order discharging defendant from community supervision. Is that the exhibit you're speaking of?
The one marked, yes, Exhibit
All
2.
right. So what it says in exhibit number 2 at the end, it says that he's released from all penalties and disabilities resulting from the crime of offense, except that proof of said conviction shall be known to the court should the defendant again be convicted of any criminal offense.
He has not yet been committed. He has not been convicted. Not only that, the case is dismissed. It's ordered dismissed. And under the Cuellar case, if you read this, and I'm tendering you a cup.
Oh, did you tender a copy to the?
Yeah, I also gave them notice of that, that under this section of the Code of Criminal Procedure, whenever a judge goes through this pardon situation, that it can't be used for enhancement. So, and this is a copy of the Cuellar case that talks about it.
All right, state.
Defense counsel would have a good argument if he was right, but he's not. Because of the language of 42.12 section 20. In subsection B, it states this section does not apply to a defendant convicted of an offense under sections 49.04 through 08 Penal Code. Those are the DWI provisions of the Penal Code. So now we have a philosophical problem. If a judge issues an order that the judge lacked the authority to make, has the judge in fact issued an order? And the answer, as far as I can tell, is no. In Ray State ex rel Hilbig, several defendants and real parties in interest were convicted of DWI felonies and were sentenced to regular probation. After completing their probation, Judge Hilbig terminated their sentence, set aside the judgments, and dismissed the indictments. The state argued that the judge had no authority to terminate the probationary periods under Article 42.1, Section 20 at the time. And the Court of Appeals of San Antonio agreed because the language of the statute means what it says. 49.04 offenses are excluded from the judicial clemency provision. Additionally, in Bradley v. State, which is admittedly not a published report, the Dallas Court of Appeals in 2002 came to the same conclusion on roughly the same facts as this. When a judge issues an order that the judge had no authority to make, we treat it as a nullity. We ignore it, which means judicial clemency was not granted for purposes of this motion to quash, and it should be denied.
Judge, he's referring to the 2015 version of the statute. This, and it wasn't in effect at that time back in 2004 when he was granted the pardon. So what counsel is saying that we can ex post facto apply the 2015 law to my client, which is untrue.
Your Honor, may I briefly respond?
Yes.
I am making reference to Article 42.12 that was in effect June 13th of 2001, which contains this judicial clemency exclusionary language. I'd also like to point out that judicial clemency is distinguishable from pardon, which Mr. Robeson has not received.
All right, so first question, was it a pardon or was it clemency?
It was a pardon. It was dismissed.
Respectfully, Your Honor, if I'm informed correctly, a pardon is something that is issued by the governor. And this order was not issued by the governor. It was issued by the judge of the court to which he was assigned for that case.
It's called a judicial pardon.
That's not a pardon. That's judicial clemency.
And the Cuellar case resolved it. That's from the Court of Criminal Appeals. Okay, it's out of Bexar County. And they said that in that case, it cannot be used. And this is current with my client's case and the statute as it existed at that time.
All right, State, have you had a chance to review the Cuellar case?
No, Your Honor. However, briefly looking at it, it seems that that covers a felon to possess firearm offense, which has nothing to do with the judicial clemency language in 42.12 section 20 subsection B.
All right, so the state's argument is that your client's offense, past offense, is excluded from not being used in this indictment. He's saying that under chapter 42, that DWI is one of those offenses that are excluded as far as whether or not it can be used for enhancement to provide jurisdiction to the felony court. And you're arguing that's not true?
I'm saying it's not true in this case because the judge allowed him to withdraw his plea and dismiss the case. And it works as an acquittal under Cuellar.
Then why does it say, and State, I understand your argument, but then why does the document say that it can be provided as proof
No,
if he's convicted of any criminal offense to the court? If someone is pardoned, then it doesn't come back as proof that you are convicted of an offense.
it doesn't say that it's proof. It's in her order, it just says that the judge could be informed of the existence of the prior judgment. It doesn't say it's proof.
No, it says, and what I'm reading, it says, it is therefore ordered. And then towards the end, it says, he is released from all penalties and disabilities resulting from the crime of the offense, except that proof of said conviction. That's what it says.
Except proof of conviction.
Of said conviction shall be known to the court should the defendant again be convicted of any criminal offense. Now, I understand what the state is saying with regards to chapter 42, but defense, you haven't addressed the issue. The defense is saying that, the state is saying that chapter 42 has been in effect since 2001.
Yes,
The part of the statute, the part of the code that he's reading from. Your client's conviction of this offense, this looks like January 7th, 2022. So wouldn't chapter 42 encompass this, since this conviction occurred after? And
2002.
yes, and the order discharging him from community supervision was signed by a judge in 2004.
Or
And the conviction date, it looks like it's 2002. State is saying that that code section 42 is from 2001.
that's when I believe that's when it went into effect.
So then if you agree that chapter 42 is from 2001 and that a state is saying that DWIs are not covered by the exhibits that you've submitted to me, then the state would be correct.
Well, it says the language that it uses is that the case was dismissed. And that the judge allowed him to withdraw his plea. So it is no longer a final conviction. So in this instance, the language of the judge caused it not to be a final judgment. And I think under those circumstances, under the Cuellar case, that means that it can't be used for enhancement of punishment in this case. It's not expungible according to the statute, but it can't be used for enhancement. And that's what Cuellar says.
All right, State, are you prepared to address Cuellar? Or do you need more time?
So, Your Honor, as far as I can tell, Cuellar is completely off the mark for this. That was a felon in possession firearm case in which the defendant's prior felony conviction was subject to 42.12 section 28 clemency. And the state argued that essentially 42.021A, 42 points. Sorry, Your Honor, I'm getting confused. 42.12 section 28 clemency should just be ignored so that the state could charge Cuellar with felon in possession firearm. And the Court of Criminal Appeals ruled that no, the state can't just ignore judicial clemency. That has nothing to do with the circumstances of this case in which a person purportedly received judicial clemency that the court by section 20's own terms, he never should have been able to receive because the court had no authority to issue it. And in this circumstance, what this court should do is to ignore that purported judicial clemency order for precisely that reason.
All right, any other argument?
That's all we have.
All right, just give me, if you'll step back, just give me 5 minutes.
Sure.
And I'll review the documents that you've given to the court. Gabriel Diaz. Counsel, have you received all discovery?
I don't know, but that I did, Your Honor. It's my first setting, Your Honor.
All right. State, were you able to tender an offer?
Not yet, Your Honor.
All right, Ms. Ferguson. If you recall this in 30 days, state you're to tender an offer at that time. All right, y'all coming back on January 14th, just have a seat and the coordinator will get you a reset.
Thank you, Your Honor.
All right,
Take a seat. Okay, please.
that's Gabriel Diaz and it's gonna be January 14th if you'll let Ms. Ferguson know when she comes back. Brandon Trader. Who's the attorney for Brandon Trader?
I'm here now.
Hi. And where's he?
He failed to appear today, Your Honor.
All right. Let me see if he has a PR bond. Deputy, could you make an announcement in the hallway for Brandon J. Trader? Well, can you tell me on Brandon Trader, was he given a PR bond? Or a commercial bond? And hi, Deputy, could you make an announcement in the hallway for Brandon Trader?
Traeger?
Trader.
Trader, gotcha.
Thank you.
Yeah, later. I appreciate you.
Hold on a second.
Your client may, I mean, it's a possibility your client may be in custody. Because I'm reading some of the details.
I asked the deputy.
Mhm.
They said that it was not in custody.
Okay. All right, court is calling 2024 CR 01075 State versus Brandon Trader. Could I have parties announced for the record for the state
Andrew Harris, Adelman.
defense?
Winnie McClellan.
All right, this hearing was scheduled at 9 a.m. It is 10:58 a.m. The defendant has not made an appearance. Defense, have you had any contact with your client?
I have not recently, Your Honor.
All right, state.
Assuming that Mr. Trader is not in the state's custody, bond forfeiture and issue a bench warrant for his apprehension.
All right, the court will issue a judge's warrant and remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Your Honor.
All right, you're welcome.
May I be excused?
Yes.
Thank
Hello, are you Justin Cowart? All right, we're trying to get in touch with your attorney, Mr. Gomez. Have you had any contact with him?
It's been off and on.
All right, just give me a moment. And did you hire him?
Yes.
All right. Could I see the file on Justin Cowart, please? All right, just give us a moment. If y'all will, they're gonna keep you in back. Just give me a moment. I'm gonna see if I can get in touch with your attorney to have him here, okay?
Okay.
All right, thank you. All right, Mr. Cowart, if you'll come down. Mario, are you able to hear us?
Yes, Judge.
Okay, awesome. All right. So, Mr. Cowart, the reason why your attorney is not here is because Odyssey has been doing some strange things. So he thought it was set on the 19th, and I have no reason to doubt that, but he did jump on to Zoom, okay? So, counsel, on this one, I know that he came back as confident. Is that correct, the last time we were here?
That's correct, Judge.
All right. Do you know if you have all of the discovery?
I believe I do.
All right. And was an offer given to you?
Not yet.
All right. What I'm going to do is I'm going to require the state to tender an offer. So if you'll get in contact with her, my understanding it's Mulliner.
Yes.
What I'm going to do is I'm going to set this for a plea deadline date. And I can set it the week of January 6th.
January 6th. For plea deadline date?
Yes.
Okay.
All right. So what date is good for you?
We said January 6th, right?
The week of January 6th.
Oh, the
So-
week of January 6th. Okay, let me check real quick. Can we do Thursday, the 9th?
Yes. All right, so we'll bring you back on January 9th, okay?
Okay.
All right, do you have any questions?
No, Your Honor.
All right, thank you so much. All right, thank you for zooming in. We'll see you on January 9th.
Thank you, Judge.
All right. Ladies and gentlemen, it's the court's understanding you've reached a verdict in this case. Is that correct? And is the verdict unanimous? All right, if you'll hand the charge to the deputy, please. Right, the verdict form appears to be in proper order. Count 1, it states, we the jury find the defendant Christopher Morrison guilty of the lesser included offense of deadly conduct under count 1. Count 2 reads, we the jury find the defendant Christopher Morrison guilty of the lesser included offense of deadly conduct under count 2. Does anyone wish to have the jurors polled? State? Defense? All right, ladies and gentlemen, I'm going to ask you if this is your verdict in each count. If this is your verdict in each count, I'll need for you to answer yes. Does everyone understand? All right, we'll start on this end. Is this your verdict?
Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict? All right, we'll start on the back row. Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict?
All right. So what I'm going to do is I'm going to have you all wait in the jury room, and then I'll give you further instructions. Everyone, please rise for the jurors. All right, everyone, please be seated. All right, so you all wish to change your election for punishment? All right. Then there being Mr. Morrison. Yeah, well, just a second. Mr. Morrison, if you can come forward. All right, Mr. Morrison, you do understand that you have a right to have the jury decide your punishment? All right. Have you had ample opportunity to discuss with your attorney whether or not you want to change your election of punishment from the jury to the court?
So Your Honor, there's one issue. Well, he has to get back in the if we have to do a PSI, has to come back.
Ma'am, I'd like to continue. After sitting in this courtroom, I drove.
Okay. All right. So we can do this we can go off the record. We can do this one or two ways. One, if you would like, I can do punishment today. Or if y'all would like, I can do punishment tomorrow so that everybody, because sometimes I understand when people get a guilty verdict, maybe you were not expecting it. Sometimes you have to get in the right mind frame to move to the next phase. So if y'all would like, we can recall it for tomorrow for punishment.
So if we could do it today, Your Honor.
Okay.
That would be ideal.
And state, what are you going to be requesting as far as punishment is concerned? I'll let you, I tell you what, I'll let you all discuss that. So what we will do is if there are no objections, I'm going to go back and release the jurors. And then you all discuss to see maybe what they're asking for, because who knows? Maybe you all can come up to an agreement on punishment. Maybe not. I don't know. All right. All right, everyone. We're going to take a short recess.